All right, that was a very lively and exciting panel. Our second panel for today has two speakers. The first one is Honorable Isabel Maria J. Zamora, who is part of the House panel of prosecutors. She is the incumbent representative of San Juan City's Lone District. Representative Zamora is part of the panel of 11 representatives who will serve as prosecutors in the impeachment proceedings of Vice President Sara Duterte. Prior to entering politics, she was a partner at Zamora Poblador Law Offices, practicing civil and family law, corporate law, and criminal law. She received her undergraduate and law degrees from the University of the Philippines and was admitted to the Philippine Bar in 2009. Our second panelist is Attorney Sheila C. Sison, a partner from Fortune, Narvasa, and Salazar. She is counsel for Vice President Sara Duterte. And Attorney Sison is a specialist in criminal litigation and has served as lead counsel of numerous Sandigan Bayan cases. She has extensive experience in criminal and civil litigation, family law, and labor law. She earned her Bachelor of Laws from San Sebastian College of Law and graduated as class valedictorian. She was the first recipient of the Academic Excellence Medal of Honor by the Recoletos Educational Apostolate of the Philippines. Ladies and gentlemen, our panelists for today.
May we call on Congresswoman Zamora and Attorney Sison to the stage for our second panel on the Duterte impeachment and lessons from the past. Thank you so much. Like the first panel, we did provide Congresswoman Zamora and Attorney Sison with a few questions over the weekend, and we're very grateful that you took the time to be with us today. The panel is going to be much shorter than the first one, but before we get to the questions that we prepared for you, would you have any reaction to the first panel, or any thoughts that you may have following the first panel that was here? Oh, I'm so sorry. So before we get to the or to the question and answer, I understand that Congressman Zamora prepared a brief remarks. Would you like to deliver them here?
Dean Darlene Barberabe, Senator Robin Padilla, former Senate President Franklin Drilon, retired Associate Justice Conchita Carpio Morales, Commissioner Rene Sarmiento, my professors in the UP College of Law, non-teaching staff, guests, students, good afternoon. I am Isabel Zamora from Batch 2008 Block C, and it is my honor to once again be in the hallowed halls of the University of the Philippines College of Law, albeit in a different and fancier location. Never in my life did I think that I would speak in front of my professors or be chosen as a prosecutor in an impeachment case, as I always regarded myself as a simple girl. The role of being a prosecutor was offered to me on our last week of sessions, and I accepted the offer for several reasons. First, I was asked if I wanted to do something for the country. Second, as vice chairperson and an active member of the Committee on Justice in Congress, I believe that it is my duty to see the complaint through. Third, I was told that they needed someone who was matalino, mabait, at maganda. So I said, hindi naman. I initially had doubts after I was nominated, as I thought I was not a great trial lawyer. But sabi nga, para ito sa bayan. I was tasked by my friends, Congress colleagues from UP Law and UP to wear something maroon on the first day and to raise the flag of UP high. I am both excited and anxious about my new task. I brought out my highlighters and post-its the following day and started reading. It brings back tons of memories from law school. I take this opportunity to mention a few aspects about the case. The complaint was culmination of a meticulous, transparent, and televised fact-finding effort of the House of Representatives. Certain matters, in fact, arose during the budget deliberations in 2023. Copies of the complaint were circulated to the members, and in fact, on the first circulation, I was already able to read the articles. Some members voiced their opinions on the matter. 215 members signed the complaint. The House prosecution will show that Vice President Duterte, since her assumption to office, has repeatedly, egregiously, and grossly violated her solemn oath and pursued actions that amount to culpable violations of the Constitution, flagrant betrayals of public trust, graft and corruption, and other high crimes. In particular, Vice President Duterte committed the following. She contracted an assassin and plotted to murder the President, the First Lady, and the Speaker of the House. She misused and malversed confidential funds appropriated for the office of the Vice President and the Department of Education. She disbursed or gave away monies amounting to graft and corruption, among others. The House prosecution has been meeting and preparing for trial to commence, as we believe that there is no other interpretation to the provision in the Constitution that trial shall forthwith proceed. I have so far been able to gather a lot of know-how, insights, and intelligence from the other panelists today and my professors today. I am extremely grateful for this opportunity, and I thank Dean Berberabe and all of you for bringing me back to the university that I love dearly. Thank you.
Dean Darlene Marie Berberabe, the Senator Robin Padilla, retired Supreme Court Associate Justice Honorable Antonio T. Carpio, former Senate President Franklin M. Drilon, retired Associate Justice Honorable Conchita Carpio Morales, Honorable Rene V. Sarmiento, Attorney Ramon Esguerra, Associate Professor Gwen Grecia de Vera, Assistant Professor Theodore Te, Congresswoman Isabel Maria J. Zamora, Attorney Fina Bernadette A. de la Cuesta Tantuico, and my senior partner in Fortuna Nervasa and Salazar, Attorney Gregorio Y. Nervasa II. Ladies and gentlemen, good afternoon. I would like to thank the UP College of Law, Justice George A. Malco Memorial Foundation, Inc., in partnership with the Philippine Law Journal, for the invitation to join this forum today that aims to encourage meaningful conversations on the emerging issues in impeachment, especially since we come to this forum as counsel for the Vice President, whom we know is now the subject of impeachment efforts. We appreciate the opportunity given to partake in today's discussion and listen to perspectives from which we could all draw some insights that hopefully would enrich the dialogue and our understanding, as well as of the public, about the impeachment process. The other night, I was reading a keynote speech that was delivered by the late good Senator Miriam Defensor Santiago in 2012, or 13 years ago. This was delivered before an annual convention of a Society of Doctors and Physicians. Now, in that speech, she cited the fundamental book on the topic of impeachment, authored by Professor Charles Black, Jr. of Yale University, and summarized as well the thoughts that the latter had on the matter. According to the late senator, impeachment is a dreadful process. It inflicts a deep wound on the country. Now, Professor Black, in his disposition in that book, described impeachment in this way, and I quote, "Removal by conviction on impeachment is a stunning penalty, the ruin of a life. Even more important, it unseats a person whom the people have deliberately chosen for that office." I understand, of course, that many who had come to this forum may probably already had formed their own opinions. This is but natural in a democratic country that values and encourages free speech. But I agree, it is a stunning penalty. It is a dreadful process. It ruins a life. In fact, I can even go one step further and state the reality that long before the impeachment process has begun, a life is already ruined by accusations made public, and with the amount of heavy criticisms made for public consumption without the benefit yet of a trial. And perhaps that is the significance of having this forum today, in that we are reminded that despite our personal convictions and or opinions on issues surrounding the current impeachment efforts against the Vice President, impeachment remains a serious constitutional mechanism that must be done only in the manner permitted by no less than our Constitution and the standards it had set therefore, in accordance with principles of fair play and the rule of law. I am hopeful that this forum would contribute to elevating the discussion among our people. Again, good afternoon at maraming salamat po.
Thank you very much, Attorney Season. Congresswoman Zamora and Attorney Season, to go to the questions that we raised over the weekend and which she gave you ahead of time, we would like to ask, how do past impeachments or past impeachment trials inform your preparation for this upcoming trial, if you could answer it? Congresswoman Zamora.
Professor Tomasa, so as I earlier mentioned, the prosecution has already been reviewing and studying and preparing for the trial. So in fact, we studied the past impeachment cases. We have a list, tables of all impeachment cases filed before the Committee on Justice, or those that went straight to plenary. And I note two particular impeachment cases. First, in President Estrada's impeachment, we know that there was an issue of the second envelope. I was not yet a law student at that time, but from my understanding, there was a need. They wanted to open it, and that was the reason why the senators walked out, because of that second envelope. So what we thought was that there's a need to sift through our evidence. We should check all the pieces of evidence that we have and see whether these are really important. Second, learning from the era of impeachment was that public support is very important, as this is a political exercise. It is political legal for some, but the influence of the public is very important, and we should muster the public support in this case. Second, that I noted was in the Corona impeachment back in 2012. If I'm not mistaken, several articles were withdrawn. I believe it was 5 articles, and that tells us on the prosecution side that we should in fact be ready with our articles. We should be able to defend these articles and have evidence for each. We should prepare so that we won't be berated by Senate, especially the lawyer senator judges, as in fact some were berated. Some of the members of the prosecution were in fact berated by Senator Miriam, if I'm not mistaken. I believe it was during that impeachment also that they were berated on rules of evidence, and this tells us that we need to have a cohesive prosecution. We have to have a firm stand and complete evidence for all of the articles.
Thank you, Congresswoman Zamora. Attorney Season, would you like to weigh in on this question?
Yes. Earlier, I was actually asking my senior partner, Attorney Audrey Nervasa, about this question. And I told him it should be you who should answer this question because you're older than me. And he was part of the Arab Estrada impeachment defense team. And I think I was still just being born at the time. So really, if there's anyone who can answer this question in this room, that would be Attorney Audrey Nervasa. But all right, kidding aside, 2 things come to mind when it comes to past impeachment trials and how it would help us in the upcoming trial. But let me just point out before I answer this question, because the premise of this question is there will be a trial. And I think I have to be candid enough to disclose that yesterday the defense filed a petition challenging the validity of the 4th impeachment complaint that was referred by the House to the Senate. But let's assume that trial would indeed proceed. How do these past impeachment trials inform the defense team? In response to the question, Attorney Audrey shared that during their time, which was 25 years ago, anything goes. There were a lot of things that happened outside the impeachment court, and I suppose that is because impeachment process really is a unique intersection of law and politics. And this is something that we also anticipate could happen and would happen this time. Because even now, prior to the Senate constituting itself into an impeachment court, we could already hear a lot of people wanting to put in their 2 cents on the matters and on all incidents, on all issues that come out of this whole impeachment process. In fact, even prior to the filing of the 4th impeachment complaint, we could already see and hear a lot of people chiming in on the things that were discussed at the hearings that were conducted by the House. And of course, this contributed to our people developing some opinions. Probably most of them are strong opinions. And so this is something that the defense would also have to prepare. Well, this is, not without, it goes without saying that we are prepared just by being the lawyers of the Vice President, that we would be under heavy scrutiny by the public. And so this is also something that we really need to prepare. But apart from the preliminaries, just like what Congresswoman Zamora said, the defense team is ready. Whether or not the petition or whatever resolution or action that the Supreme Court would have on the petition that we filed yesterday, the defense team is ready. Now, on the details of the preparation that we had done, I think that it would be prudent on my part not to disclose yet the level of preparation or the things that we are doing at the moment in order to be able to come to the trial well prepared.
I understand the limit, and nonetheless we're very grateful that you actually agreed to our invitation to join the conversation this afternoon.
Yes, that's as I advised you when you extended the invitation to us. I really cannot disclose or discuss any matters pertaining to evidence, strategies, or defense. That's why there was a question that I actually requested you to take off the list, because it's really something that I cannot talk about.
Which we also removed the equivalent question for the prosecution.
Yes, I understand.
So, but I hope the next question isn't, you'd be willing and free to answer regarding questions about the Senate rules. And unfortunately, despite impeachment being political, and that's something we learned from the first panel, inevitably, the proceeding itself is likely to be couched in law. And, it will involve statutes, it will involve the Constitution itself, and the rules of the Senate. So, having looked into the current Senate rules for impeachment, is there anything coming from the conversation the earlier panel or throughout your preparations which you think or you would want the Senate to consider or reconsider as part of the impeachment process?
Exactly. There's actually one. Proceeding from the discussion earlier and from what has been discussed even in media, there is Section 11, if I'm not mistaken, that an adjournment of the Senate sitting as a trial court shall not operate as an adjournment of the Senate as a legislative body. So, in my humble opinion, I think that the reverse should actually be stated as well, so as to remove all of these issues on whether we can proceed with trial.
Thank you, Congresswoman Zamora. Attorney Sison, would you have anything to suggest?
I actually prepared 2 items in respect of this question, but based from the discussion that we had with our legal experts in the first panel, it would seem that the general track or agreement, at least, is that there could be no standard of proof or the degree of proof by which impeachment cases can be decided by the Senate. And whether it is clear and convincing, substantial evidence, mere preponderance of evidence, or beyond reasonable doubt, proof beyond reasonable doubt. I think that is something that we could agree is not included in the rules just as yet. And I would understand why. It's because if you read the rules on impeachment, really the senators, judges would mostly be deciding on the entire matter of the impeachment, as well as the incidents or the mini incidents that will crop up in that trial, based only on their conscience and based on the oath that they will be administered, that they would promise that they will do impartial justice. So one of the items that I wanted put, if I have my way, would be, a certain standard by which the impeachment process would be decided. And the reason for this is not because I want a higher quantum of proof. Of course, I want a higher quantum of proof. I'm a defense counsel. If it's gonna be, if I have my way now, Senator Padilla, would you, consider putting in a standard of proof that, it's proof beyond reasonable doubt, or probably much, if there's any higher creature than that degree of proof. But the reason why I want some standard put in the rules is because, isn't it also in the public interest that we have some uniform standard by which the senators, judges would be able to consider every incident and motions that would come up in the trial? Because then it would lend not a semblance of legitimacy, but it would at least deflect questions on whether the proceedings that were conducted by the Senate and the rulings that the senator judges made were legitimate or at least fair. The second, of course, is just, on the more practical considerations. Perhaps it's also for the benefit of the prosecution team or Congressman Zamora. Perhaps both parties, if trial would indeed happen, perhaps a set timeline of everything, the submissions of motions, the examinations of witnesses, just so both parties or clear expectations are set for both parties. I guess this is also because largely this would be a public affair, and by public affair I mean everyone will want to, watch the proceedings and see how it's going.
Attorney Yun, if I can, ask a follow-up question on that. Does it mean that the defense and Congressman Zamora, the prosecution would, for example, be open to, let's say, a pre-trial proceeding before the Senate, or where for the non-lawyers, where basically the parties present the witnesses that they will present the fixed list of the evidence that will be presented? And I think that the Corona impeachment has something like that at the very least, or even almost pre-trial discovery, as what the Nixon versus United States Senate did. If only you're comfortable with answering that question.
It's for me.
Yes.
I think the general consensus is to make the trial conform with the standards rules or fair rules, but also for the trial to proceed in an efficient manner. That's where I'm coming from. If the rules would be able, or the Senate would, for example, be able to come up with something definite, something that both the prosecution and the defense would have to say in respect of the proceedings that would be conducted in the Senate, I think that would be in keeping with giving the entire process not expediency, but some order that no one would be able to question the legitimacy of the entire process, or even, the separate votings that the senators, judges would eventually make on some issues.
Congresswoman Zamora, your thoughts?
Actually, I agree with her statement that there should be some order to the proceedings. Going back to the standard, to the requisite standard that we need to convict. I agree with my Professor Te that it should be something that will convince a senator or even a layperson to remove the official. It should be convincing enough that it carries a consequence. Then the consequence that he or she will be further disqualified from having future office. I remember also the standard mentioned by Bernas on his impeachment rank. Since it is a political exercise, the standard is his gut feel. So it is the gut feel of the senators that is required. And while I know that isn't a lot, and we cannot quantify that, it goes back to process being a political exercise.
Thank you, Congresswoman Zamora. We do have just one last prepared question before I think we can go to an open forum, and I hope the first panelists can join us again for that. The last question is, should public be able to influence the trial as a political exercise? And if so, to what extent? And for the non-lawyers, those who are outside of law, generally, if it were a court proceeding, and to a certain extent even an administrative proceeding, we really don't want the public to weigh in on how a judge or an administrative judge would rule on a particular case or complaint. But I think both speakers recognize, the earlier panel recognizes, that impeachment isn't really a strictly legal proceeding. It's a mix, at the very least, of a legal and a political proceeding. So in your opinion, right, should the public be able to influence the trial as a political exercise? Vice President Duterte is a popular figure, as much as the perceived people who are against her also have their own base of support. So your thoughts, please.
I think it shouldn't be a question whether the public should be able to discuss or talk about the impeachment process, but the question really is whether or should the public be able to influence, so meaning there's some level of exertion, of influence. By how? Probably by information that are circulated in social media, the mainstream media, etc., etc. In Professor Black's opinion, what the public should do in cases of impeachment really is to do what he refers to as vigilant waiting. And I agree to some extent that even as we allow the public to speak on matters that affect, their interest or the accountability of our public officers on some alleged and purported wrongdoings, I believe that it would be better that there has to be some balance. Now, whether the public should be able to influence how eventually the senators would have to decide on the impeachment case, I think that's another matter. But one other thing, and to my mind this is what's more important, that this forum, our fellow lawyers, and of course our law students would probably be able to to help in terms of elevating the quality of public discussion. And this is because it's important that even as we encourage our people to speak on matters of national concern, we should be able to help them sift through and navigate through the facts and be able to separate facts from fiction, and to be able to assess evidence-based assertions over mere propaganda or rhetoric or grandstanding.
Thank you, Attorney Season. Congresswoman Zamora.
I think what the Attorney Season said is actually very good. In fact, that we should really elevate the discourse, the level of discourse as regards impeachment. I guess for both sides there are many things that are circulating, and we have to keep it to what we have as facts only. I think being a political exercise, of course, the public will always influence. In fact, if the question is should the public influence, yes, but maybe to a certain extent, maybe to we should limit it to what is within the bounds of law, what is proper, maybe what is fair, and I think that we should allow both sides to also be able to present their evidence properly, completely in trial, and I know that for the senator judges, there will always be political considerations, even if we have our evidence. Both sides would have their evidence. The political considerations will always come into play. So that's my take on that.
Thank you very much. A round of applause for our panelists. We did allocate a few minutes for an open forum, so if I can bother our speakers from the first panel to join us again on stage to hear questions from our audience, both here and on live stream. Thank you. Thank you, and I do apologize for bothering you a second time, audience. We do have, while waiting for anyone to ask here, we do have one question from the online panel. And I think it was, spurred by the remarks of Attorney Season. So I think the question is, given the fact that public office is a public trust, how do we weigh the personal consequences to the impeached official against the public benefit of impeachment? And I think, just to add a little more complexity to that question, we've been talking about the whole afternoon on standards of clarity of evidence and the others. When in doubt, right? How do we weigh? Is it the potential public benefit or the potential public harm on the public officer?
I think there's really no contradiction in the two. It does not mean that when you try to protect the personal rights of the person under scrutiny in an impeachment case, it necessarily, or in our case, if we are the counsel or represent the vice president, it does not mean that the work that we will do in defending her or putting up the best defense available for her, as we are mandated to do under our legal ethics, it does not necessarily mean that we are in effect thwarting the public benefit that will come out of the trial. I guess what I'm saying is, for as long as the legitimacy of the impeachment process is clear, and that there has been no infringement of any constitutional rights, and that constitutionally imposed standards are complied with, then it does not really matter who you represent, whether you're for the prosecution or the defense, or whether the question of there was some public benefit that was derived from the entire impeachment process. I think the public benefit question would even be subject to what it is really that came out of the trial that we could consider to be a public benefit, if at all.
Thank you very much. Other questions from the audience? Yes, please. Kindly introduce your name and let us know to whom you're directing the question.
Sa lahat. Sound check. Sa lahat po. Romy Maglunsod po from MTC Alliance, BTS Party List. Ang tanong ko lang po, kung magkaroon ng impeachment trial at ang sabi ng prosecution evident naman na maganda yung kompleto naman ebidensya nila at ang bansa natin magkagulo-gulo dahil nga merong malaking paksyon ng Duterte, malaking paksyon ng Marcos, malaking paksyon din yung ayaw sa kanilang dalawa. Ano ngayon na mapapala ng taong bayan kung sakaling matanggal natin ang Vice Presidente sa pamamagitan ng impeachment trial? At kung sakaling mag-resign naman ng Vice Presidente, mauulit lang ba uli yung nangyari sa impeachment trial ni Pangulong Erap na nakatakbo uli siya? Naging mayor pa uli ng Manila at parang wala ring nangyari, sabi nga ni Justice Morales, ituro daw sa electorate, ituro sa mga botante. Parang ang nangyayari sa impeachment trial, wala rin kaming napapala eh. After ng impeachment, makakatakbo uli yung ipinapa-impeach natin. Hindi ba tayo nagsasayang lang tayo ng pera ng taong bayan?
Thank you po. So, anyone from our panel who would wish to answer the question? If I can kindly nominate Prof. Gwen. It's a very difficult question. I think that goes into the there's a larger discourse now about how, compared to the Corona and the Estrada impeachments, where you basically have two sides, right? This one involves a more fractured society where there are many different political sides involved this time. So, is it really just a waste of time? And if I can rephrase that question.
So, thank you for having been voluntold. The tables have turned. I have been called for recitation. No, but seriously, siguro po, hindi naman sa nagpapasa ako ng voluntold kasi magbibigay naman po ako ng, susubukan ko pong sagutin yung inyong tanong dahil mahalaga po yung inyong tanong, no? Pero baka maaari po din nating ayayahan mamaya si Congress Representative Zamora, no? Dahil sila po yung sila po ang naghain, no, nung impeachment complaint at nabanggit din po niya kanina kung bakit niya tinanggap yung paanyaya sa kanya maging miyembro ng prosecution panel. So makikita po natin doon yung kahalagahan nung impeachment process. Pero subukan ko po kayong sagutin. Hindi ko po mababanggit na bata po ako nung mga nangyari yung mga unang impeachment. So nasubaybayan ko po yung parehong impeachment, no? Yung impeachment ni Pangulong Estrada at yung impeachment din po ni Chief Justice Corona. Masasabi ko po na lalo na po nung impeachment at impeachment trial ni President Estrada, napaka highly politicized po yung buong proseso na yon, no? Umabot nga po tayo nung pinag-uusapan natin kanina, isa pong kadahilanan kung bakit hindi natuloy yung kanyang impeachment trial dahil nung ayaw buksaan yung envelope, no? Nag-walk out din po yung ating prosecution panel, no? At matapos po nun, dahil din po dun sa ayaw na pagbukas ng envelope, nagkaroon po tayo ng EDSA 2. At matapos po ng mga pangyayari na yon, si Pangulong Estrada ay lumisan po mula sa Malacanang at ang sabi nga po ng Korte Suprema, siya po ay nagbitiw, no? Nagbitiw sa pagkapangulo dun sa kanyang pagkakaalis sa Malacanang. So, sa kabila po ng mga pangyayari, no, nung panahon na yon, nasubukan din naman po nating tingnan kung hanggang saan natin mapapatakbo yung impeachment trial, no? At nabigyan po ng pagkakataon, hindi lang naman po yung prosecution panel at yung senator judges at yung defense team na subukang ipaliwanag sa taong bayan na nagmamatsyag po noon, no, nung first impeachment at yung pangalawang impeachment sa mga pangyayari. Pareho pong impeachment na yon, gaya po ngayon, naanyayahan din po ang UP College of Law at yung mga profesor na tumulong na ipaliwanag yung mga kaganapan nung parehong impeachment proceedings na yon. So, sa usapin po kasi natin ngayon, parang hinuhusgahan natin ang benepisyo at kahalagahan ng impeachment proceedings. Depende po kung ano ang kanyang magiging resulta, no? Kung natanggal, kung binawian ng kakayanan na tumakbo pa at maglingkod sa bayan, na hindi nga po natin nagawa noong panahon ni Pangulong Estrada. Sa aking palagay po, ang kahalagahan nitong proseso na to, dahil ito ay ilagay natin sa saligang batas, ay ang kakayanan ng mababang kapulungan at ang Senado, at maging ang Korte Suprema, no, dahil nakita po natin ang partisipasyon ng Korte Suprema sa paglalabas ng mga desisyon, no, lalo na po nung kapanahunan ng impeachment ni Chief Justice Estrada, ang mapalawig ang pagtunawa natin, no? Hindi lamang sa nilalaman ng saligang batas, kung hindi ang buhay politika sa Pilipinas. Kasi ito po yung isang pinanghahawakan natin, no? Na maaari natin, lagi natin binabanggit dito, public accountability. Okay? Na maaari po nating singilin sa mga hinalal natin, no? Sa mga na-appoint sa posisyon na kailangan inyong ipakita, no? Ang hindi lang kakayanan, kundi na kayo ay karapat-dapat na patuloy magpatuloy sa inyong posisyon at maglingkod sa bayan. So napakahalaga po nung inilagay natin itong proseso na to sa ligang batas at ipinapatupad po natin ito. So nandun po sa akin yung, maaari ba hindi natin nakikita agad yung benepisyo dahil sa isip natin, ang benepisyo nitong proseso na to, matanggal yung opisyal at hindi na siya mabigyan ng pagkakataon na mahalal, no? O mabigyan pa ng posisyon sa gobyerno. Pero sa akin, may kahalagahan yung proseso kung talagang nabanggit nga ni attorney kanina, no, yung vigilant waiting na bukod sa Senado, bukod sa mababang kapulungan, bukod sa Korte Suprema, tayo mismo, no, magmatsyag ng mabuti. Gaya nga po nung nangyari nung kay President Estrada, na napag-usapan natin ngayon yon. Sinabi na siya ay nag-resign. Ang sinasabi po ng mga panelists natin kanina, may kakayahan ang Senado noon at may kakayahan siya ngayon na kung nais ipagpatuloy upang siya ay hindi na po mahalal muli dahil magkakaroon na tinatawag natin perpetual disqualification, maaari po sana isinulong yon kahit noon po man. Pero ngayon na alam na po natin yun, alam po natin na yun ang resulta na ayaw na nating mangyari, na ipaabot na po siguro natin sa Senado ngayon ang ating pag-iisip sa bagay na yun, ano? Sa bandang yun, na may kakayanan ipagpatuloy ang impeachment trial upang makapagpasya ang Senado, kahit na nag-resign na po, bumitiw na po ang opisyal, may kakayanan magpasya ang Senado na sabihin hindi na siya maaaring mahalal pa muli o mabigyan ng pagkakataon na magkaroon pa ng posisyon sa pamahalaan.
Thank you.
Sana po nakatulong yung sagot po.
I think Congresswoman Zamora, if you wanted to respond, and then Commissioner Sarmiento, I think also wants to respond. And then I think, for lack of time, we'd have to end the forum on this question.
Thank you po. So without going to the merits or to the evidence, it is our duty as representatives, as members of Congress, to file this impeachment complaint because we saw grounds to support the articles that we have. Gaya po ng sinabi ni Professor De Vera, kailangan nga po natin na mailabas sa taong bayan yung ebidensya. Hindi po siya waste of time, hindi po siya waste of resources, because there is separate consequence of disqualification from holding another public office or any public office in the future. Hindi po nagtatapos sa resignation ng isang impeached or impeachable official. Pwede pong ipagpatuloy ng Senado ang trial para malaman natin kung dapat nga bang ma-disqualify yung official from holding public office. So kami naman po sa Kongreso, may nakita kaming ebidensya, kaya po kami nagsampa ng complaint for impeachment.
Commissioner Sarmiento?
Tatlo po ang pakinabang na nakikita ko po sa usapin ito ng impeachment. Una-una, serves as a political education sa ating taong bayan. Natatandaan ko po doon sa Estrada proceeding, ako po ay komentarista ng Channel 5 every after trial, every session, at marami pong interesado. As a matter of fact, a survey was conducted that because of these impeachment proceedings, maraming gusto tumaas ang enrollment ng mga kolehiyo because of these impeachment proceedings. Natuto sa proseso. Pangalawa, yayaman ang ating jurisprudence kung ito po ay masagot ng ating Korte Suprema. Yayaman ang ating pagkaintindi ng constitutional processes, or isas dalawa ng sinampa. Baka may susunod pa. That will enrich jurisprudence for the sake of our future law students and future generations. Pangatlo po, it will serve as a deterrence, no, sa mga gustong tumakbo, manungkulan. It's a warning na pag kayo ay hindi gumawa, hindi maglingkod sa taong bayan, ito ang consequence na posibleng mangyari. So para sa akin po, this exercise is a fruitful exercise for all of us. Estudyante, magulang, lahat ng sektor ng ating lipunan.
Thank you, Commissioner Sarmiento. So sa dami ho ng tanong na ilabas today, yun po ang pinakamahirap. Salamat po na nasagutan po ng ating mga panelists. Thank you again to our esteemed panelists and speakers for today. Can we please give them one last round of applause? So, as our panelists go down the stage, I would just like to, and before we call on our Chair of the Malcolm Foundation for his closing remarks, we would just like to thank the UP College of Law Office of the Dean the Malcolm Foundation, the Philippine Law Journal, certain offices in the UP Law Complex, such as the Information and Publication Division, ICTO, and the UP BGC administrative staff, Ms. Cristel May Parungao, my research assistants, Nick Castro of the class of 2025, Jill Chua, Jules Espino, RD Mercado of the class of 2026, and Block 1 BGC Day 2, who served as our ushers today for helping us organize this program. We have two brief announcements before Justice Carpio gives his closing remarks. The first is that the transcripts of today's proceedings will be made available by the Philippine Law Journal in its new website. You may visit philippinelawjournal.org in a few days in order to see the transcript. The second is that coming from the preparation by the UP College of Law of a primer on impeachment and frequently asked questions. We have heeded the instructions of our dean and the request of the public to prepare translations of the impeachment primer and frequently asked questions, which will be made available in the UP Law website later this week. They will include a Filipino or Tagalog translation, an Ilocano translation, and a Cebuano translation for the general public. So please stay tuned for that. It is my honor to call on the chair of the Malcolm Foundation and former Senior Associate Justice Antonio T. Carpio to give his closing remarks and to end today's program.
Tanggalin niyo. I think he just arrived from a different engagement, so he kindly asked me if I could. And the interpretation of a former clerk in Justice Carpio's office and a colleague for the longest time is that that was not a request. So thank you. That put the Constitution at the center of the national conversation. And in our nation's history, other than revolutions, perhaps it's impeachment that often takes over the national consciousness once it happens. We moved fast to hold this first forum because in the age of disinformation, it would be unfortunate for inaccuracies to dominate the conversation. Our hope for these events is to provide a venue for studied and measured argumentation, not a Twitter war, not a troll fight. Because what is unfolding is the greatest of proceedings involving a constitutionally elected official. We are thankful for the quality and quantity of participation today. We have a packed auditorium, an overflowing online registration, and partnerships to broadcast and live stream this nationwide. Days like these are a good measure of good citizenry. We are also thankful, of course, for Professor Paulo Tamase and his conscripted labor force, his students. They put this together practically over the weekend. We in the Malcolm Foundation are spoiled with this good work. And of course, we are thankful for the full support of Dean Lelen Berberabe, whose guidance in all of these events have proven invaluable. We look forward to more events like this because with the filing of the third petition in the Supreme Court regarding impeachment, it is safe to say, parating pa lang tayo sa exciting part. Kasi as I was telling two panelists earlier, maybe the next topic should be, we keep on hearing impeachment is political. Ano ba ibig sabihin ng political? So yes, simula pa lang to. At paulit-ulit po tayong magkikita at mag-uusap, magpapalit ng pananaw at makikisalimuha sa isa't isa. Dahil hindi po ba ito ang sentro ng masiglang demokrasya. At pagdating sa impeachment, maaring senador ang boboto.
pero di natin makakaila. Bayan ang humuhusga sa ating lahat. Maraming salamat po.
Thank you, Professor Molo. That ends our impeachment forum for this afternoon. Thank you for joining us here in UPBGC and in our live streaming channels. For our speakers, may we request that you just come up here below the stage for a brief group photo. Our speakers and special guests, as well as the faculty, are